Hello, everyone. I'm Sagar Rach, owner of Rach Law, a business law firm that serves our business clients' personal and business needs in Nevada, California, and other states. I'd like to chat with you today about partnership disputes and some of the outcomes that partners can expect if there is a dispute between two or more partners. And when we say partners, I don't mean a legal partnership necessarily. I mean a LLC, corporation, partnership certainly, and any other business arrangement where two or more parties are working together and might have ownership of the business or the business's interests together. Today's video, I want to really focus on some of the outcomes that partners can expect if there is a dispute. We've had other videos on our channel, and I hope you guys can certainly see those that talk about what a dispute is, how to identify them, pre-litigation issues, litigation issues, and so on. But one of the most common questions I get asked is what happens if there's a dispute? What are the potential outcomes that can occur if two people who are partners can't agree to the business? Whether that's how to run the business, whether one partner is taking more money out than the other, whether one partner is not pulling their weight, whatever it is, those type of issues can certainly lead to disagreements and potentially a fight between the partners. But legally speaking, there are a few solutions. In our other video, we talked about, potential mediation, arbitration, things like that. So there are ways to try to resolve partnership disputes without going to court. If either a conversation between the partners or a mediation results in some sort of resolution, the parties can usually agree to those through a settlement agreement. Hey, look, we've had the disagreement. Here's how we figured out how we solved that disagreement so that we can keep running the business going forward. That's certainly doable. If there's an arbitration, then there's a decision maker that's rendered a decision on, hey, look, this is what should happen with the business. Whether it's an arbitration, whether it's a demand letter that's received, both sides necessarily might not agree with the decision that's made. So what happens in a case where two sides just can't agree to work out the difference? Well, certainly there's litigation, there's court, right? You can, an attorney, generally in our experience, will send a demand letter out first. If the matter is not resolved, then file a lawsuit. However, there's other things that can be done just short of filing a lawsuit. And what are some of those? Well, first, if the partners are just at such odds that it doesn't seem like there's any kind of a potential future viability of the business, then it's a possibility that the parties might have to dissolve the business. They might have to wind the affairs of the business, which means they'll have to take care of the liabilities, take care of the costs, take care of anything regarding the assets of the business, any leases, any other obligations will need to be taken care of. Whatever assets are left over gets split up, and the parties basically close down the business, file their final tax return, file the documents that are required of the state and federal agencies, and so on. Certainly, closing the business down is a drastic step, but a lot of times it's an important and unfortunately necessary step if the parties just can't agree to keeping the business going. If the parties say, okay, the business should keep going, then the partners can either decide that they want to be bought out by the other partner, in which case certain buyout documents will need to be taken under consideration. One of the partners might bring in a third party to replace them, in which case both sides will have to come to an agreement on what those terms are. Or both of the partners can say, look, this might not work. We don't necessarily want to shut it down. We at least want to get some value out of it. Let's sell the business. And that's also doable. The business can be sold to a complete third party that buys the business. That's a bona fide purchaser of value. It's not related to any party that comes in and buys the business. And both parties can look at the proceeds and whatever's left over, allocate those between each other, depending on whether it's profits or losses. The decision on which way to go is really, really very fact specific. There's no magic formula that can be given where I can say, if this happens, then you have to do this. If this happens, then you have to do this. We've had cases where one of the partners has gone MIA. We've had cases where one partner is refusing to put in money in the business. We've had cases where partners gone off the grid and decisions can't be made. Lots of different scenarios take place where the strategy to be chosen really depends on the facts. So a law firm like ours can certainly help you do that. If you do need help, please always feel free to give us a call. You can reach us for a free consultation at 702-758-4240 or at www.rachattorneys.com. Thank you for watching. I hope today's video was a little bit useful as to the potential outcomes that you might have. please feel free to give us a call at your earliest convenience, and we'll talk to you soon. Thank you.